CFMEU boss Zack Smith was tight-lipped as he arrived at the federal court this week. As he left, the future of his union was still up in the air.
Zack, are you going to fight the application to appoint an administrator?
I don't have any comment to make today.
What about the allegations against the CFMEU? What do you have to say in response to that? It was the first hearing of the Fair Work Commission's bid to appoint an administrator to the embattled construction union. 270 CFMEU officials would be removed from their positions, including Zack Smith. So far, it's not clear if the CFMEU will oppose the action, but indications are it's gearing up for a fight.
Nothing will stop this union continuing to negotiate and sign enterprise agreements that deliver the wages and conditions that you deserve as construction workers. Your union, the CFMEU, is here to stay.
Allegations against the union include using thuggery and standover tactics to take control of taxpayer-funded infrastructure projects.
Essentially amounting to criminal infiltration of the construction and general division of the CFMEU, that people with associations with bikie gangs and organised crime have ended up in positions of significant influence within the organisation.
The Victorian branch of the CFMEU has been the focus of many of the allegations, with the state government announcing its own inquiry. 7:30 can reveal 5 days after that announcement, one company bidding for work on Victoria's biggest infrastructure project, the suburban rail loop, was told it needed the CFMEU on its side. On July 25th, an Indigenous company seeking a job on the project emailed a subcontractor organising work packages for the suburban rail loop, asking, "As discussed, we are sending our rates shortly. Can you please confirm if the EBA for these works have to be with the CFMEU?" In response, the subcontractor says, yes, EBA agreement would need to be in line with CFMEU, unless something has now changed with Lang O'Rourke. Is that something that's appropriate?
Well, as I've made clear some time ago, and also too, there is also work that is being undertaken by the federal government through the Fair Work Commission, and we are seeing that work being implemented this week.
I'm surprised that a contractor would be putting that in writing, quite surprised, particularly with all that's happening. But it's also indicative of the fear, I guess, of retribution that contractors or head contractors live under or construct under.
If it was the case that the reason that they didn't get that work was because they refused to enter into an agreement with CFMEU rates, then there is the possibility that that breaches provisions in the Fair Work Act prohibiting unlawful coercion, that is, pressuring another organisation into entering into a union agreement. And that is a provision that has civil penalties attached to it.
Does it show that despite the revelations, though, about the CFMEU and your review, that the CFMEU is still effectively calling the shots on big bill projects?
I'm not going to comment on any specifics.
The Indigenous business did not have a CFMEU agreement and did not get the job. Managing contractor for the suburban rail loop, Lang O'Rourke declined to comment. Is the CFMEU still telling contractors that they need to sign CFMEU EBAs? No comment today, Mr. Smith?
That's it. Thanks.
Master Builders New South Wales boss Brian Seidler says he's also aware of companies in his state being told they need an agreement with the union to get work.
If the answer is no, then the information we receive is that the union will put forward a number of contractors who do have agreements with them, and the contractor will have to choose from that list. So fundamentally, it's the union regulating the labour market on major construction projects.
What we've seen is contractual arrangements between CFMEU-controlled companies and state governments. That's exactly what we seek to investigate in this inquiry.
Today, the Coalition announced it will push for a Senate inquiry into the CFMEU, which would be able to compel witnesses and provide protection for those too afraid to go public with their concerns.
Concerns have been raised from various quarters this week about the absence of administrators' powers to compel people to produce documents, to provide evidence, and also the inability to protect whistleblowers or people who want to provide that kind of information. That is a gap. I don't think that could be filled in a court-appointed administration.
Our job is to get to the bottom of this and for Parliament to do its work. If the Senate inquiry is to get up, both those construction companies doing sweetheart deals with the CFMEU will be under as much investigation by the Senate inquiry as the CFMEU and its officials itself.
After this week's federal court process stalled after the presiding judge recused himself because he'd acted as a barrister of the former construction watchdog, the ABCC, the federal government is now expected to bypass the court process altogether by introducing legislation as early as Monday to appoint an administrator to the CFMEU.
Criminal activity. It has seeped into the culture of the union. It's now poisoned it. And that is why it's something that has to be addressed in terms of current plans for legal intervention to try and turn this around.